Question 1. A notary public is asked to notarize a document that has several blank spaces. The signer states they will fill in the information later. The notary should A. Proceed with the notarization as long as the signature line is filled. B. Advise the signer to fill in the blanks before the notarization can be completed. C. Notarize the document and make a note in the journal that blanks were present. D. Fill in the blanks with "not applicable" and then proceed with the notarization. Answer: B. Advise the signer to fill in the blanks before the notarization can be completed. A notary must never notarize an incomplete document, as this creates a significant risk of fraud. The core concept here is preventing fraudulent alterations after the notarization is complete, as someone could later fill in the blanks with unauthorized terms. For example, a blank space for a loan amount could be filled in with a much higher number after the signer has left. As a best practice, always require the signer to either fill in the blanks or draw a line through them before you proceed with the notarial act. Question 2. The primary purpose of a notary's surety bond is to A. Protect the notary from financial liability. B. Protect the public from financial harm caused by the notary's misconduct. C. Serve as an insurance policy for the notary's employer. D. Pay the notary's state commissioning fees. Answer: B. Protect the public from financial harm caused by the notary's misconduct. The surety bond exists to protect the public, not the notary. This is a crucial distinction, as the bond acts as a financial guarantee that reimburses a member of the public who suffers a financial loss due to a notary's error or intentional wrongdoing. If a bond is paid out, the notary is then legally obligated to repay the surety company for the amount of the claim. Think of it as a safety net for your clients, ensuring there is a source of funds to cover damages if you make a critical mistake. Question 3. A signer appears before a notary but seems confused and disoriented, unable to understand the document they are being asked to sign. The most appropriate action for the notary is to A. Ask a family member to explain the document to the signer. B. Notarize the document but make a note of the signer's condition in the journal. C. Postpone or refuse the notarization until the signer is lucid and aware. D. Proceed with the notarization if the signer is able to physically make a mark. Answer: C. Postpone or refuse the notarization until the signer is lucid and aware. A fundamental requirement for any notarization is that the signer must be aware, willing, and competent at the time of signing. If a signer appears unable to comprehend the nature or consequences of the document, the notary has a duty to protect them by refusing to perform the notarial act. Proceeding would be improper because the signer lacks the necessary mental capacity to enter into the transaction knowingly. To remember this, ask yourself, would this person be safe signing this document right now? If the answer is no, you must refuse the service. Question 4. When completing the venue section of a notarial certificate, the state of and county of information must reflect A. The county where the signer resides. B. The county where the document will be filed. C. The location where the notarization is taking place. D. The notary's county of residence. Answer: C. The location where the notarization is taking place. The venue establishes the geographical location where the notarial act occurred, which is a key component of the certificate's legal validity. This information indicates where you and the signer were physically present at the moment of the notarization, confirming that the act happened within your jurisdiction. For instance, if you meet a signer at a coffee shop in Los Angeles County, the venue must state State of California, County of Los Angeles, even if the signer lives in a different county. Always fill in the venue based on your physical location during the signing. Question 5. A notary is a commissioned employee at a bank. A customer asks the notary to select the correct notarial certificate for their document. The notary should A. Choose the acknowledgment certificate as it is the most common. B. Refuse to perform the notarization. C. Explain the different types of notarial acts and ask the signer to choose. D. Ask a bank manager to make the decision for the customer. Answer: C. Explain the different types of notarial acts and ask the signer to choose. A notary who is not a licensed attorney is prohibited from choosing the type of notarial certificate on behalf of a signer, as doing so constitutes the unauthorized practice of law, UPL. The correct procedure is to describe the available notarial acts, such as an acknowledgment, confirming identity and voluntary signing, or a jurat, swearing or affirming the truthfulness of the document's contents, and allow the signer to make the selection. By explaining the options without giving advice, you fulfill your duty while avoiding UPL. A simple rule is, you can describe your services, but you can't prescribe a solution. Question 6. If a notary public's official seal is lost or stolen, the first action the notary must take is to A. Order a new seal immediately. B. Notify the commissioning authority, such as the Secretary of State, in writing. C. Purchase a new surety bond. D. Inform all clients from the past 30 days. Answer: B. Notify the commissioning authority, such as the Secretary of State, in writing. The security of your official seal is paramount, and its loss must be treated as a serious security breach that could lead to fraud. State laws universally require that a notary immediately report a lost or stolen seal to their commissioning official, which is typically the Secretary of State. This official notification creates a public record that the seal is compromised, protecting both the notary and the public from any fraudulent use of the missing instrument. Your first call or written notice should always be to the state authority that granted your commission. Question 7. A signer needs a jurat performed on an affidavit. Which of the following is a mandatory element of administering a jurat? A. The notary must witness the signer signing the document. B. The signer must present 2 forms of identification. C. The notary must read the entire document aloud to the signer. D. The signer must provide a thumbprint in the notary's journal. Answer: A. The notary must witness the signer signing the document. The core purpose of a jurat is for the signer to swear or affirm that the contents of a document are true, and the certificate confirms this oath was taken in the notary's presence. Because the certificate states the document was subscribed and sworn to, or affirmed, before me, the notary must physically watch the signer execute the document. Unlike an acknowledgment where the signature can be pre-signed, a jurat requires the signing to happen during the notarial ceremony. Remember, for a jurat, seeing is key, you must see the pen hit the paper. Question 8. A person asks you to notarize the signature of their spouse, who is not present. The person has their spouse's driver's license and a signed permission slip. The notary must A. Refuse the notarization. B. Perform the notarization since the person has the spouse's ID. C. Allow the person to sign on behalf of their spouse. D. Complete the notarization and note the spouse's absence in the journal. Answer: A. Refuse the notarization. The foundational rule for nearly all notarial acts is the personal physical appearance of the signer before the notary. This requirement allows the notary to positively identify the individual and assess their willingness and awareness, which is impossible if the signer is not present. No form of identification or permission slip can substitute for the actual presence of the document signer. Think of it this way: your primary duties are to verify identity and witness the act, neither of which can be done for someone who isn't there. Question 9. Which of the following is an example of an acceptable form of identification for a notarization? A. A student ID card with a photograph. B. A state-issued driver's license that expired 1 month ago. C. A valid passport from a foreign government. D. A credit card with a photograph. Answer: C. A valid passport from a foreign government. Acceptable identification must be issued by a state or federal government agency and contain the signer's photograph, signature, and a physical description. While rules vary slightly by state, a valid foreign passport is almost universally accepted as a primary form of ID. In contrast, student IDs and credit cards are issued by private entities, and many states, like California, have strict rules against accepting expired IDs, even if recent. An easy way to remember the standard is to look for a current, government-issued document with a photo and signature. Question 10. A notary signing agent's role during a loan signing appointment primarily involves A. Explaining the interest rate and loan terms to the borrowers. B. Verifying the identity of the signers and notarizing their signatures on loan documents. C. Providing legal advice about the consequences of the loan agreement. D. Negotiating the final closing costs with the borrowers. Answer: B. Verifying the identity of the signers and notarizing their signatures on loan documents. A notary signing agent, NSA, has a specialized but limited role, to act as an impartial witness to the signing of loan documents. The NSA's duties are strictly notarial and administrative, focusing on identifying the signers, ensuring all documents are signed and dated correctly, and performing the required notarizations. Critically, an NSA is prohibited from explaining loan terms, providing opinions, or giving advice, as this would be the unauthorized practice of law and mortgage lending. The key is to remember that the NSA's job is to manage the signing process, not to interpret the documents. Question 11. Which of the following must be included in a notary's journal entry for every notarial act? A. The signer's occupation. B. The fee charged for the notarization. C. A photocopy of the document being notarized. D. The name of the person who referred the signer. Answer: B. The fee charged for the notarization. While specific journal requirements vary by state, recording the fee charged for the notarial service is a nearly universal mandate. This creates a clear and transparent record of the transaction, protecting both the public from overcharging and the notary from false claims. Other essential elements typically include the date and time, the type of notarial act, the document title, the signer's name and signature, and how the signer was identified. Think of the journal as the official business record of your notarial acts, where financial details are just as important as the procedural ones. Question 12. A signer presents a document in a foreign language to be notarized. The notarial certificate is in English. The notary does not speak the language of the document. The notary may A. Notarize the signature if the notary can communicate with the signer and all other requirements are met. B. Refuse the notarization because the notary cannot read the document. C. Require the signer to provide a certified translation of the entire document. D. Only notarize if the document is translated by a professional interpreter in the notary's presence. Answer: A. Notarize the signature if the notary can communicate with the signer and all other requirements are met. A notary's duty is to notarize the signature on a document, not to certify the document's contents. Therefore, a notary is not required to be able to read the document itself, as long as the notarial certificate is in a language the notary understands. The critical requirement is that the notary can communicate directly with the signer to verify their identity, ensure they understand what they are signing, and administer the oath or acknowledgement properly. So, if the certificate is in English and you can confirm all legal requirements with the signer, you can proceed even if the main body of the document is in another language. Question 13. Which of the following represents a prohibited conflict of interest for a notary public? A. Notarizing a document for a coworker. B. Notarizing a real estate document for which the notary is the named grantor. C. Notarizing a document for a personal friend. D. Charging a fee to notarize a document for a stranger. Answer: B. Notarizing a real estate document for which the notary is the named grantor. A notary cannot act as both a principal signer and the officiating notary in the same transaction due to the direct financial or beneficial interest. When a notary is a party to the document, such as a grantor, seller, on a deed, they are no longer impartial and cannot legally notarize their own signature or the signatures of other parties on that document. Notarizing for coworkers or friends is generally permissible as long as the notary has no direct stake in the transaction's outcome. Always remember, if you are a signer or beneficiary named in the document, you cannot be the notary for it. Question 14. An acknowledgment certificate is used to A. Certify that the contents of a document are true and correct. B. Verify that the signer appeared before the notary, was identified, and admitted to voluntarily signing the document. C. Create a certified copy of an original document. D. Administer an oath to a witness who will be testifying in court. Answer: B. Verify that the signer appeared before the notary, was identified, and admitted to voluntarily signing the document. The purpose of an acknowledgment is to certify the circumstances of the signing itself, not the truthfulness of the document's content. With an acknowledgment, the notary confirms that the signer personally appeared, was properly identified, and acknowledged that they executed the document for its stated purposes. Unlike a jurat, the signer does not need to sign in the notary's presence and does not swear to the document's accuracy. A helpful way to distinguish this is to remember that an acknowledgment is about confirming the act of signing, while a jurat is about swearing to the facts in the document. Question 15. If a document is presented for notarization without a pre-printed notarial certificate, the notary should A. Refuse to notarize the document. B. Draw a seal and sign on the document below the signer's signature. C. Ask the signer which type of notarization is needed and attach the appropriate loose certificate. D. Type a notarial certificate directly onto the document. Answer: C. Ask the signer which type of notarization is needed and attach the appropriate loose certificate. It is the notary's responsibility to complete a notarial certificate for every act performed, but they cannot simply stamp and sign a document. If the document lacks the necessary certificate wording, the correct procedure is to ask the signer to choose the type of act, e.g., acknowledgment or jurat, and then attach a separate, loose certificate containing the proper state-approved wording. This ensures the notarial act is legally compliant and clearly documented. Always remember that the notarial certificate is your official statement, and it must be complete and correct. Question 16. A notary's official journal is considered A. The personal property of the notary, which can be discarded after the commission ends. B. Public record that may be inspected by any member of the public upon request. C. The property of the notary's employer if the employer paid for it. D. A confidential record that must be kept secure and surrendered to the proper authority upon commission termination. Answer: D. A confidential record that must be kept secure and surrendered to the proper authority upon commission termination. A notary's journal contains sensitive personal information about signers, so it must be kept under the notary's exclusive control in a locked and secure location. While members of the public can request to inspect a specific entry, they cannot have unrestricted access to the entire journal. Upon retirement or resignation, state laws typically require the notary to surrender the journal to the county clerk or another designated official, confirming its status as an important public archive. The rule of thumb is to treat your journal with the same security as your seal, as it is a crucial tool for protecting the public and yourself. Question 17. A signer is physically unable to sign their name and wishes to execute a document by making a mark. The notary should A. Refuse the notarization as a full signature is required. B. Have the signer make their mark, and have one or two witnesses observe the act as required by state law. C. Sign the document on behalf of the signer. D. Allow a family member to guide the signer's hand to make the mark without witnesses. Answer: B. Have the signer make their mark, and have one or two witnesses observe the act as required by state law. Notary laws provide a specific procedure for individuals who are physically unable to write their name but are otherwise competent. This process typically involves the signer making a mark, such as an X, in the presence of the notary and one or two impartial witnesses. The witnesses then sign the document to attest that they observed the signer making their mark, and the notary records the witness's information in the journal entry. This legally validates the mark as the equivalent of a signature, ensuring access to notarial services for all capable individuals. Question 18. A notary makes a minor error in the notarial certificate after completing it. The correct way to fix the error is to A. Use correction fluid or tape to cover the mistake and write over it. B. Destroy the document and have the signer start over with a new one. C. Draw a single line through the error, write the correct information nearby, and initial and date the change. D. Affix a new seal over the error to obscure it. Answer: C. Draw a single line through the error, write the correct information nearby, and initial and date the change. The professional standard for correcting an error on a notarial certificate is to maintain transparency, so the original mistake remains legible. By drawing a single line through the incorrect information, you are not attempting to hide it, you are simply nullifying it before adding the correction. Initialing and dating the change authenticates the alteration, showing it was made by the notary at the time of correction. Using correction fluid, erasing, or completely obscuring an error is forbidden because it can raise questions about the integrity of the document. Question 19. A notary is generally prohibited from certifying a copy of A. Power of attorney. B. Journal entry from their own notary journal. C. Birth certificate. D. Letter written by the document custodian. Answer: C. Birth certificate. Notaries are typically forbidden from making certified copies of vital records like birth, death, or marriage certificates because a certified copy of such a document can only be issued by the official government agency that holds the original record, e.g., the county recorder or a state's Department of Vital Records. This rule prevents fraud and ensures the authenticity of these critical life documents. A notary can, however, perform a copy certification by document custodian, where the document's holder signs a statement attesting to the copy's truthfulness, but this is a different notarial act. Question 20. The primary difference between an oath and an affirmation is that A. An oath is sworn to a deity, while an affirmation is a solemn promise on one's personal honor. B. An oath is used for depositions, while an affirmation is used for affidavits. C. An oath must be spoken aloud, while an affirmation can be written. D. An oath requires 2 witnesses, while an affirmation does not. Answer: A. An oath is sworn to a deity, while an affirmation is a solemn promise on one's personal honor. Both an oath and an affirmation are legally binding verbal pledges that the information a person is about to provide is true. They are functionally equivalent and carry the same legal weight and penalties for perjury. The key distinction is their basis. An oath is a religious vow, often including the phrase, "So help you God," while an affirmation is a secular promise made on one's personal honor, for individuals who prefer not to reference a divine being. A notary must offer the choice between the two to respect the signer's personal beliefs. Question 21. Which of the following is an example of the unauthorized practice of law, UPL, for a non-attorney notary? A. Charging the maximum fee allowed by state law. B. Explaining the difference between an acknowledgment and a jurat. C. Advising a signer that a power of attorney is the best document for their needs. D. Refusing to notarize a document with blank spaces. Answer: C. Advising a signer that a power of attorney is the best document for their needs. The unauthorized practice of law, UPL, occurs when a non-attorney provides legal advice or services that require a lawyer's expertise. Recommending a specific type of document, such as a power of attorney, constitutes legal advice because it involves analyzing a person's situation and prescribing a legal solution. A notary's role is strictly to perform the notarial act requested, not to counsel the signer on what document they should use or what its legal effect will be. To stay safe, always remember to be the gatekeeper of the notarial process, not the author of the legal journey. Question 22. When a notary public changes their legal name, they must A. Continue using their old name and seal until their commission expires. B. Immediately notify their commissioning authority of the name change. C. Order a new journal and discard the old one. D. Only notarize documents for family members until a new commission is issued. Answer: B. Immediately notify their commissioning authority of the name change. A notary's commission is issued under their official legal name, and all notarial acts must be performed under that same name to be valid. If a notary changes their name, e.g., through marriage or court order, they are legally required to inform their state's commissioning authority, typically the Secretary of State, within a specified timeframe. The state will then provide instructions on how to proceed, which usually involves filing an amended application, obtaining a new seal with the new name, and updating their bond. Continuing to notarize under a former name would invalidate the notarizations. Question 23. Most states require that a notary's journal be kept for a specific period of time after the last entry. A common retention period is A. 1 year. B. Until the notary's commission expires. C. A minimum of 5 to 10 years. D. Indefinitely. Answer: C. A minimum of 5 to 10 years. Notary journals serve as crucial evidence of notarial acts and may be needed for legal proceedings long after the act is performed. For this reason, state laws mandate a specific retention period, with many states like California requiring journals to be kept for 10 years, while others may require 5 or 7 years. This ensures that a reliable record exists even after the notary's commission has expired. Always check your specific state's law, but remember that the journal's life extends well beyond the date of your last notarization. Question 24. A notary may charge an additional fee for travel expenses if A. The travel distance is more than 10 miles. B. The travel fee is not greater than the notarial fee. C. The signer agrees to the travel fee separately and in advance of the travel. D. The notary is self-employed. Answer: C. The signer agrees to the travel fee separately and in advance of the travel. While states set maximum fees for notarial acts themselves, e.g., $15 per signature notarized, they generally permit notaries to charge a separate fee for travel. The critical rule is that this travel fee must not be part of the official notarial fee and must be disclosed to and agreed upon by the signer before the appointment. This ensures transparency and prevents the signer from being surprised by an unexpected charge. Always quote your travel fee up front and document it separately from the statutory notarization fee in your journal. Question 25. A notary is asked to act as an authorized representative to complete and sign Section 2 of a Form I-9, Employment Eligibility Verification. This action is A. Prohibited, as it constitutes the unauthorized practice of immigration law. B. Permissible, as it is not a notarial act. C. Only permissible if the notary is also a licensed immigration consultant. D. A notarial act that must be recorded in the journal. Answer: B. Permissible, as it is not a notarial act. Completing a Form I-9 as an authorized representative is not a notarial act. The person is simply acting as a designated agent for the employer to verify an employee's identity and employment authorization documents. No notarial seal or certificate is used, and the act should not be recorded in the notary journal as if it were a notarization. Because it is outside the scope of notarial duties, any person can be designated by an employer to do this, but notaries are often asked due to their experience with verifying identity. The key is to understand this as a separate role and not to apply any part of the notarial process to it.